Welcome to the fourth episode of Beyond Retirement Learning Series. This is sponsored by Senior Edge Legal, and I'm Susan Graham, a certified elder law attorney based in Boise, Idaho. This program will take approximately 20 minutes, and the topic today is estate planning using irrevocable trusts. I know your goal is to gather information and see if I might be a good team member for you, but my goal is threefold: to give you information to help you have a secure future, and to provide free legal forms that everybody needs. In addition, I want to show you how you can meet with me if you choose to, if you think that might be of help to you. Anytime during this program and afterwards, you can just fill out that form that's on this page and click the submit button. Now, let's talk about what we're going to discuss today. I want to wind back just slightly. Remember, in the earlier episodes, I told you there are three pillars to estate planning. The first pillar is assess your current situation and figure out where you want to go for the rest of your life. In the good days, the bad days, which I'm referring to, you mentally or physically can't really fully care for yourself, and then when you die. The second pillar is come up with a plan to bridge that gap. One or more things that can help you accomplish your goals. And the third pillar is actually create that plan. Do the paperwork that's necessary and coordinate your assets to align with your plan and keep that plan up to date. So today we're going to continue on the second pillar, coming up with a plan. We're going to talk about irrevocable trusts. Last episode we talked about revocable trust. A revocable trust is something, remember, that you put your assets in, you're in charge, you decide who the backups are, how things are handled when you're in the good days and the bad days. And you can change, it's called revocable because you can change it anytime you want. You can change who inherits from you, you can change those terms, you can change the assets that are in the trust, you could also change who's in charge. So you can change it anytime you want. But when somebody finally dies, that trust becomes irrevocable, meaning nobody else can change that. And even though they may not like it, the assets are going to be distributed the way you said, and the people that are going to be in charge are the ones you chose. Well, there are other kinds of irrevocable trusts that are set up, and I'm going to talk about four of them. Now, I can't do that in great detail. We'd need to go to law school and have months and months of classes, but I'm going to give you the points that you're going to care about. One of them is we call an heirloom trust. It's got lots of names. It's called a dynasty trust, a heritage trust, a legacy trust. There are all kinds of names. Who cares what the name is? We currently call them heirloom trusts. This is an irrevocable trust. See, this one you can't open up. It's got a lock on it, and I'm going to show you how this is used. This is a trust that's available to protect the inheritance your children receive from you. It's called an asset protection trust. I'll get back to this in more detail in a moment. There's another kind of trust I'm going to talk about, which is a supplemental needs trust. This is a trust for people who are on disability. Many of the disability programs say that if you have the person who's disabled has more than $2,000 in assets, they're pushed off the disability program. And we don't want that to happen. So this is a trust where we protect their disability benefits and still have funds to help supplement that. There's another trust. We call it a Medicaid qualifying trust. Now this has got two locks on it. And I'll talk about how you can use this kind of irrevocable trust to help an individual qualify for the government Medicaid programs or the VA programs. And then there's another one we call a love and protection trust, and that's for people who unfortunately have children who are in the state penitentiary or who are living under the bridge and really are having a very difficult life. And if you give them an inheritance, if you can even find them to give it to them, usually it's lost pretty quickly because people fleece them or they just don't have the mental ability to manage it appropriately. So they use it for drugs or alcohol or give that away or let people cheat them. So let's go to this one. This one is we call this an heirloom trust. So if you give $300,000 to a child and that child just receives that 300,000 from you, that's fine. That's great. But if, let's say, you give 300,000 to your son when you die, and then 2 years later your son dies, most likely what's left of that 300,000 will go to his spouse. And then should she remarry husband number 2, and then she dies, I'm going to bet you money that the 300,000 is going to go to husband number 2 and not the grandchildren. So in order to prevent that, if you have the 300,000 go into this irrevocable trust, then when the son dies, you've controlled it even though you're dead, and you're going to say it's going to go to the 3 grandchildren. It's not going to go to wife number 2. So that's one great feature about this. Another feature about this is if your son should divorce, his wife has no claim on the property that's in here. As opposed to if he received it outright, he may have put it in a joint account with his wife, and then she would have a claim against a portion of that inheritance. This money is also protected from divorce, not only divorces, but from creditors, lawsuits, and bankruptcy. Very powerful. And when that passes to your grandchildren, they would have the same protection. This can go on for future generations. That all sounds cool, but what's the point of having an inheritance if you can't spend it? Well, the law is created so your child, your son, could be his own trustee if you desire to have that happen. And it's still protected. He can invest it and do what he wants. But it also says he can take the money out when he chooses to. He can take that out. The words that we use are for health support, maintenance, and education. Pretty fuzzy words. But he wants the money, he takes it out. But if somebody is knocking on the door saying, you owe me $100,000 for that car wreck, give me the money, he can say, go away. And there's no way that they can force this money to come out. So that's one very valuable and powerful estate planning trust that you can use. But this is an irrevocable trust. So when the money drops in here, nobody can change those terms. There's another trust that's a Medicaid qualifying trust. If you need to qualify, and we'll talk about this in more detail later on, but let's say you need to have some help with paying for the cost of long-term care in your home, assisted living, or skilled nursing care. As I mentioned before, care in your home is maybe $25 an hour for a bath aide and other people to come in, or up to $11,000 to $18,000 a month for 24-hour care. Assisted living or memory care is $3,000 to $6,000 a month, and skilled nursing care is $8,000 to $10,000 a month, which nobody can afford to pay, even if you're working full-time. So one of the ways you pay for that is out of pocket, or you have long-term care insurance, but eventually you may need to apply for assistance from the federal government, from the Veterans Administration, or from Medicaid, the state and federal program that helps pay for long-term care. Under the state and federal program, the Medicaid program, they say, okay, I'm going to, again, pick on you if you're a single person. The rules are different for married, that we'll talk about in more detail later. But if you're a single person, to qualify for Medicaid, you have to have less than $2,000 in assets. And you say, well, that's no problem. I have a house and I've got $300,000 in CDs. I'll give my house away to my kids, and I'll give the CDs away to my kids, and I'll be down below $2,000 so they can pay my nursing home care bills. Well, the government is not stupid. They figure that out. So they say if you gave away your assets within 5 years of applying for these benefits, you won't qualify. If you can anticipate that decline, you can put assets like that, a cabin, a house, a brokerage account, CDs, into an irrevocable trust. Now, you can't use that as a piggy bank, so basically people put their rainy day money in here. And normally you name, I've got 2 locks in here because I don't want one child walking away with the money. So often you name 2 children or somebody you truly trust to hold on to those assets. You, the one who created it, have no power to change this or to access those funds. That's why it's called irrevocable. See, once you put the money in, you can't change it, you can't take it out. But you give the trustee power to take out the money. And so they normally just hold the funds for 5 years or more, but should you ever need to apply for Medicaid, and more than 5 years have gone by, this will be ignored. And then these funds can be used to help supplement what benefits you're receiving from the government. Pay for flowers that come once a week, once a month, pay for massages, even pay for your grandchild's college education or other things. And then when you die, the balance of these funds go to your family. And if it's impossible for you to get through that 5-year period, there are techniques for the trustee to give that money back to you to figure out some other plan. The Veterans Administration has a 3-year, we call it a look-back period, not the 5-year that the Medicaid plan has. So this is another irrevocable planning technique you can use. This is what we call a special needs trust. See, again, you can't open this box. And what happens, you can say, when you die, the money does not go to that disabled grandchild and blow that child off of the disability benefits. It goes into this trust. And it's called a supplemental needs trust, sometimes a special needs trust, because it says it's to be ignored. It is only to supplement the benefits that are being received under the government programs. So it does not destroy that child's ability to continue to receive those disability benefits, but it can enhance their life. If nothing else, if they're so disabled and they always want to go to Disneyland, and the only way they're going to get there is with a private jet and extra specialized personnel to fly them there and have an appropriate facility for them to stay in, and then to return them, and it enhanced their life, all this money, if that even costs $30,000 to get them there, this is going to be ignored. And then when that child or grandchild dies, this again will pass wherever you said you wanted to go, and it won't go to reimburse the state for those expenses. I also have clients who have children who literally live under the bridge, which is terrible, but that's just life. And they've tried rehab, and for whatever reason, they don't have the mental or the physical ability to maintain a stable lifestyle. It's possible to put money in a trust similar to this that is managed for that child's benefit, that can pay for their health insurance and their health expenses, can pay for the rent directly to whatever facility they're living in, and to provide any other support that that child needs. But the child cannot grab that money and waste it. And again, whatever's left in this, you get to decide where it's going to go. So irrevocable trusts, there are lots of variations, but those are some of the highlights. There are very powerful ways to follow the plans that you have and protect the people that you care about so that your assets are used the way that pleases you and enhances your life and their lives. Now, I want to encourage you again to complete the form on this page and then click that submit button. If you choose to meet with me, there will be someone from my office who will contact you. There's no charge for that first meeting. They'll ask you a few questions to see if we're a potentially good fit. I want to thank you for taking the time to listen to this program. The next one is going to be about professionals for your team. Thank you.